The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oh yay, oh yay, oh yay. All persons having a manner of form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Our first case is number 20-1793, Graham versus Dar. Mr. Byrd, are you there?
Yes, Your Honor.
Good to have you with us, and you may proceed.
Well, may it please the court, good afternoon, Your Honors. Andrew Byrd here from Charleston, West Virginia, on behalf of the appellant, Janet Graham, administratrix of the estate of Edna McNeely. It's a privilege to be with you. Your Honors, the issue in this case is narrow. Did the district court err in its interpretation and application of the West Virginia Medical Professional Liability Act's loss of chance statute? Now, on behalf of the appellant, we respectfully submit that the answer to this question is yes. So my job here today is to provide the court with the roadmap of how we get there. So to start today, there are some brief but important facts that need to be discussed with the court. Ms. McNeely was admitted to Appellee Bluefield Regional Medical Center and underwent a cardiac catheterization procedure, which was performed by underlying defendant, Dr. Dar. Now, following the procedure, Ms. McNeely's condition began to deteriorate, and a CT scan confirmed a retroperitoneal bleed. Now, what's important to note to this court is that the appellee does not have the capabilities or on-site cardiac surgical backup to address this scenario. So, Ms. McNeely had to be transferred to Roanoke Memorial Hospital for surgical intervention. Now, the key facts that surround this case is the timing of the transfer of Ms. McNeely, which can be found in two medical records in the record before this court. When you look,
that involved what, flying a helicopter from Bluefield to Roanoke?
Absolutely, Judge King. First, though, there was a patient care activity medical record that shows that the decision and contact by the appellee to Roanoke to say, hey, we need to transfer Ms. McNeely was at 9:35 p.m. And you can find that at page 129 in the appendix. Now, Ms. McNeely was to be transported within an hour of that time frame, but for some reason, she was not transported until 12:24 a.m. and did not arrive at Roanoke Memorial Hospital until 12:53 a.m. Now, unfortunately, Ms. McNeely passed away as a result of septic shock due to that retroperitoneal bleed. Now, the appellant's expert, Dr. Scott DiNardo, which is an interventional cardiologist out of North Carolina, in his report, he opined that the appellee breached the standard of care by failing to follow what's called the West Virginia Cardiac Catheterization Standards, which are implemented by the West Virginia Healthcare Authority. Now, those standards state that in a situation like Ms. McNeely, she needs to be transferred within 1 hour of contact made by the appellee to Roanoke Memorial Hospital, which is the facility with on-site backup surgical procedures, and that this time period cannot be extended unless the Healthcare Authorities Board approves it. Now, in his deposition, Your Honors, Dr. DiNardo was asked about the probability.
Counsel, can I ask you a question?
Yes, Your Honor.
You mentioned at the beginning of your argument that this case has a narrow question about the interpretation of the West Virginia statute. So I'd like to get your thoughts on that interpretation. If you prove that Ms. McNeely had a greater than 25% chance of survival if the doctors did everything right. So if you prove that she had a greater than 25% chance of survival if everything had gone correctly, what's next?
Well, Your Honor, to take your question, we have to look at the practical sense of how this would be before a jury. See, in the Medical Professional Liability Act, what your question relates to is the special interrogatories that would be presented to the jury. So there'd be three. One would be, did BRMC or the appellee breach the standard of care? The second one would be, do you find by a preponderance of the evidence, and I'll read for the statute, Your Honor, that the failure to follow the accepted standard of care deprived the patient of a chance of recovery or increased the risk of harm to the patient. And then special interrogatory number 3 would be, to a reasonable degree of medical probability, do you find by the preponderance of the evidence that following the accepted standard of care would have resulted in a greater than 25% chance that the patient would have survived in this case? Because this is a case of survivability, because it's a wrongful death matter. So to answer your question, Your Honor, it would be a 3-step process in special interrogatories on the verdict form.
So just to back up, so you mentioned the third step was kind of the step I asked you to assume at the beginning. If you have a greater than 25% chance of survival, then you still have to prove, obviously there was a breach of the standard of care, that breach increased the risk to Mrs. McNeely. And then do you agree that you have to prove that increased risk was a substantial factor in bringing about the ultimate injury?
Yes, and that would be what I would call special interrogatory number 2. And that is a jury determination, because in West Virginia case law, the statute, there is no bright line rule or guidance on what is considered a substantial factor. But when you look at the common law, that is a jury question under the negligence prong.
Can I ask a question?
Yes, Your Honor.
Is that essentially a different way of saying proximate cause? So,
Your Honor, the loss of chance theory in West Virginia is what's been looked at as a relaxed causation approach, meaning that it eliminates the traditional proximate cause approach, and you just focus on those 2 prongs. The loss of chance is divided into 2 prongs. It eliminates the traditional notion of proximate cause, but yes, it is another way of proving causation under the MPLA in West Virginia.
So just to clarify, the substantial factor, proximate cause, is separate from the greater than 25% chance of survival if everything had gone right. Those are 2 separate inquiries.
Absolutely, and you can see that in the statute, Your Honor, and in the Davis decision that was cited by the district court in its opinion. Judge Berger, the district judge in that case, came straight out and said, listen, plaintiff has to do this, but they then also have the burden to prove, and you can see in the statute, to a reasonable degree of medical probability, which calls for your expert to come in and say, greater than 25% chance of survival.
So in other words, what the statute says is that if everything went right and you still had a less than 1 in 4 chance of surviving or doing well, you can't file a loss of chance lawsuit, right?
And to put that in facts in this case, Your Honor, if you look at when she was supposed to be transferred, if they would have followed the standard of care, she would have had a 39.17% chance. So she would have greater than 25%. If my expert would have come forward and said, you know what, she was so far gone, she had a 23% chance of survival at that point, if they would have followed the standard of care, case is over.
Right. Thank you.
And so
that's pretty much the whole case right there, isn't it?
It is, but I'm sorry, I think I might have cut the judge.
No, that's all right. I'm used to being cut off.
I think Judge King was getting ready to ask the question. I apologize.
Your asserted problem is that Judge Faber failed to understand or apply that 25% figure in the proper way.
Well, he read the 2 prongs together, Your Honor, and he defined his own. He took the liberty to define substantial factor on his own and blended it into the 25%, which there is no case law. It does. I mean, the statute to me is just clear. There's 2 prongs to it. You have 2 ways to go: improved recovery, survivability. But he took it upon himself to define substantial factor, which the West Virginia legislature, the statute doesn't do, and no case law in West Virginia does either. Now, I will admit, though, there are courts around the country that have taken that leap, but we don't have that in this situation.
Didn't he do it the same way your expert did it?
He took my expert's loss of chance calculations, but then did not apply it properly to the clear language of the statute. And that's one of the errors that I want to talk about with the court, is I've kind of broken down the errors of the district court into 3 areas: interpretation, application, and rationale. So when you look at the court's interpretation, you can find that.
Now, is this interpreted and applied by the Supreme Court of Appeals of West Virginia?
It has not, Your Honor. It has not been interpreted and applied. Now,
Has it been interpreted? It's been interpreted and applied to other district courts, federal district courts in West Virginia.
I don't think it's been interpreted and applied, Your Honor. It's just been briefly discussed, is how I would say. And now,
how about by the circuit courts in West Virginia?
I have not found any opinions that do that. And I will just be blunt, Your Honor, the medical malpractice attorneys in West Virginia rarely use that, but as a young lawyer, I decided I was going to use it and plead it in my complaints.
Has anybody did anybody ever propose to Judge Faber that this issue ought to be certified to the Supreme Court of Appeals?
No, Your Honor, actually, they did not. And like I said, that'd be a case of
including yourself. You didn't make any such proposal.
No, Your Honor.
Right, and the other side didn't make any such proposal.
No, Your Honor, not from the record.
But this is strictly a state law issue, right? The application of a state law.
Absolutely. I will say, though, that in my research before this argument, this court has, back in 1966, touched briefly on the loss of chance theory, but didn't get into any interpretation of the statute. But yes, I agree with you.
In 1966, you say?
Yeah, there's an opinion called Hicks versus U.S. that I was, in my research, that I found that where you all discussed the loss of chance. I'm sorry.
A tort claim case?
You're exactly right, Your Honor.
The tort claim case, and who on the Fourth Circuit wrote an opinion?
Your Honor, if you give me 1 second, I can tell you.
Thought you'd be able to tell me right off the bat. But this loss of chance theory has been floating around for a long time in West Virginia. And no law.
Actually, Your Honor, it did not come into evolution until 1983 with Thornton versus CA.
With Fourth Circuit in 1966.
Yeah, they reviewed a case out of Virginia. And it was a federal.
Oh, they did?
Yeah, Federal Tort Claims Act, where a Navy officer's wife had died at the military compound, and they brought a claim regarding that.
Well, Thornton is the case where that the word substantial came out of. The court used the word substantial in Thornton. I think that's how it sort of worked its way into the statute.
Yep, exactly right, Your Honor. Thornton talked about the substantial factor and how it increased the risk of harm. And then later in 2003 came the enactment of the loss of chance statute.
And
Judge King, did you have something else?
I'm waiting. You were going to tell me who wrote that opinion.
Oh, man.
Don't you waste time on that. That's fine. But it's a 1966 case. We'll find it.
Soboleff? Is that?
Simon Soboleff? Sure.
Proposition that he said in that case, Your Honor. He said if there was any substantial possibility of survival and the defendant has destroyed it, the defendant is answerable to them. So I kind of like the proposition.
It didn't have that 25% thing in it, though.
No, it did not, Your Honor.
Okay. And is that the unique thing about the West Virginia question?
Yes, Your Honor. It created that separate burden that, as you know, would be a separate special interrogatory on the verdict form. And so you would have a 3-step process, I was telling Judge Rushing. And that it's a unique one.
Yeah. Okay.
But Your Honors, like I said, if you just look clearly at the interpretation, the application, and the rationale behind it, you cannot reach the result that the district court did. But the one thing I want to also point out, Your Honor, when he denied my motion to alter or amend, he took it upon himself to define substantial factor. The district court concluded, and this you can be found on page 227 in the appendix, that the 25% language was to ensure that the alleged negligence was indeed a substantial factor. And as I was talking with Judge Rushing, there is no bright line rule or guideline to talk about substantial factor in West Virginia yet. Nobody's taken that leap. And in fact, if we look at the Davis opinion that the district court cited,
Then why should we be doing it for them?
I'm
Mr.
sorry?
Byrd? This is a federal court, a federal appeals court. We don't make West Virginia law. We apply it if we can figure out what it is.
absolutely. And
You're
that's
supposed to tell us what it is.
so the law in this case is easy, Your Honor. When you look at the facts and the application of that to the law, Miss McNeely had a 39.1% chance of survival if BRMC, the appellee, would have followed the standard of care. We met prong two. We met prong three on the verdict form. Prong two would have been for the jury to determine about the substantial factor. And so we respectfully submit, Your Honors, that the district court committed reversible error and abused its discretion when it did not apply the clear and unambiguous language of the West Virginia loss of chance statute. And I see my time is up, and I'll address any more questions on rebuttal, Your Honors.
Thank you, Mr. Byrd.
Thank you, Judge King.
Mr. Fox?
Okay, thank you, Your Honor. My name is Sam Fox. I'm an attorney with the law firm of Flaherty, Sinsmall Bonasso here in Charleston, West Virginia, and I represent the appellee Bluefield Hospital Company, DBA Bluefield Regional Medical Center. Before we get into the argument, there are a couple of facts that I do think I'd like to add to the case. This patient was a 78-year-old female who had approximately a 20-year history of coronary artery disease and lung problems. She'd had a coronary artery bypass graft along with multiple stents placed in her coronary vessels. On March 10th of 2016, at approximately 1:45 in the morning, she presented to the hospital's emergency department where she was assessed and evaluated and admitted to the hospital. Later that same day on March 10th, she was evaluated by a cardiologist, the co-defendant, Dr. Dar in this case. Dr. Dar and the patient decided that the patient needed to undergo a cardiac catheterization. The catheterization was performed, and following the catheterization, the patient was admitted to the hospital overnight. There's no criticism in this case of the performance of the cardiac catheterization. The criticism comes the following afternoon when plaintiff's experts critical of Dr. Dar for not ordering the transfer of this patient sooner and for not transfusing the patient with packed red blood cells sooner than what occurred. Later that evening at 9:35, there was an order to transfer the patient. A call was made to Roanoke for the patient to be transferred. The helicopter, and earlier somebody asked about the helicopter flying from Bluefield to Roanoke. Actually, the helicopter flew from Roanoke to Bluefield to pick up the patient and then back to Roanoke. That occurred. The patient was accepted by Roanoke at 22:40 or 10:40 in the evening. The life flight came from Roanoke at 22:52, arrived at the patient at 23:31. So that would have taken approximately 39 minutes for the patient, for the transport team to get from Roanoke to the hospital, to Bluefield. The transport team remained with the patient for 34 minutes, providing care to the patient at Bluefield, and then took another 48 minutes to transport the patient by helicopter back to Roanoke and arriving at 12:53 in the morning.
Were they have any weather issues or anything like that?
No, there were not weather issues, Your Honor. So at the conclusion of the discovery in this case, we moved for summary judgment, and the basis for our summary judgment motion was the fact that the plaintiffs had failed to produce any expert testimony proving that the hospital, my client, that there was any proximate cause between the alleged deviation from the standard of care and this patient's ultimate death. plaintiff's sole expert on standard of care and causation, as Mr. Byrd has pointed out, is Dr. DiNardo. He prepared a report on April 12, 2019, which was a 6-page report, 10 paragraphs in the report. Only 2 paragraphs dealt with my client, Bluefield Regional Medical Center. He was then deposed on July 5th, 2019. And during the course of that deposition, again, he offered no proximate cause opinions with regard to my client. So neither in his report or in his deposition did he ever testify or place in writing that in his report that the hospital alleged.
So, counsel, can I ask a question?
Certainly, Judge.
So the judge ruled on the 25% part of the statute.
That's correct.
So let's talk about that. What's your response to your counsel on the other side's suggestion that your reading or the district or the judge's reading of the statute collapses substantial factor in with 25%?
Well, certainly the substantial factor is an issue that the appellant in this case just totally ignores throughout this entire case. And in fact, when the question was asked by you earlier today, and Mr. Byrd addressed the statute and how it would appear in front of the jury, again, the word substantial factor was omitted. And Judge Faber and the district court got this exactly correct, because he made the point that without utilizing the substantial factor in this case, you could have a situation where there's an expert testimony that the patient, due to the negligence of a defendant, lost 25.01%. But later on, despite the negligence, the patient still may have had a 24.99% chance of survival. So it's totally irrational and illogical to allow.
Well, you're not.
Yes.
I think that doesn't mean the person wins their case. They still have to prove to the jury that was a substantial factor in causing the injury, and you would have a great argument that very small reduction in or increase in risk or reduction in chance suggests it wasn't a substantial factor.
Well, that's a legal question that's certainly ripe for a district court judge or a trial judge to deal with, because if they can't even prove that the difference in the outcome was greater than 25%, then it never should be presented to a jury in the first place. So I had a question
about 25% change in outcome. So obviously that's not what the statute says. So I'm just going off what the district court said here. But if we're looking for a 25% change in outcome, it looks to me like the district court's math is wrong, right? Because the district court subtracted the 2 percentages from each other and called that a percentage change. That's a change in percentage points, right? 25% of 39% is 14%. And if you subtract 14.17 from 39.71, that's 29.3775%. So the district court didn't take, sorry for all the numbers, but my point is the district court didn't measure a 25% change in outcome. The district court subtracted 2 percentages and used that number, but that's not a 25% change. Do you follow me?
I believe so. I was never very good in math, Judge, but I will tell you this, that to this point, there's been no dispute among the parties over Judge Faber's calculations in this case. In fact,
I guess my point is not that that we're going to reverse him on faulty math, but it's that if he's creating a 25% change in outcome rule, which is not in the text of the statute, if that's really what it means, then perhaps the rule that was applied is the one that's absurd, because the smaller your chances are, the smaller absolute change you have to show. It still only has to be 25% of what your chances were. And if that's the rule, that doesn't make much sense.
Well, the testimony in this case is that when the patient, if the standard of care had been met, the patient would have had a 39.17% chance of survival at 10:35 in the evening. The patient was ultimately received at Roanoke Memorial Hospital at 12:53 in the morning, And at that point in time, using the plaintiff's expert's own calculations, the patient had a 16.17% of survival. Therefore, nothing that the hospital did or didn't do prevented the patient from having that 16.17% chance of survival. So it's certainly reasonable.
Mr. Fox,
yes, sir.
Let me just ask you a question about the point that Judge Rushing made. This statute says that what they have to prove is that if the care had been acceptable, the patient would have had a greater than 25% chance of survival. So in other words, this statute says, the way I read, that if you're pretty much of a goner, if you have less than a 1 in 4 chance of doing well or surviving, you can't bring a loss of chance case. But if you have greater than that, you do. And that's pretty much what the plain language of the statute says, isn't it?
Well, Judge, that's what the statute says, but the statute, the text of the statute is not clear, however. It needs to be.
Mr. Fox, this business of substantial comes in a preceding clause, and the adjective substantial refers to the decrease of likelihood of a good result or the increase of the likelihood of a bad result, but it doesn't relate to the 25% rule that's in the last clause of the statute.
Well, Judge Berger from the Southern District of West Virginia, in the Davis case, she has indicated, which was a Federal Tort Claims Act case, she indicated that in essence, the substantial factor concept now has a statistical minimum standard of proof. And the history of the loss of chance in West Virginia, Your Honor, is the Thornton versus CAMC case in 1983 established loss of a chance. And it used the terminology contained in the first clause of this statute, talking about increased risk of harm, must be a substantial factor, et cetera. And then in 2003, when our legislature revised our Medical Professional Liability Act, it added, and I think tried to provide some meat to the bones, so to speak, this greater than 25% chance of improved recovery or survival. And that's what the federal courts in West Virginia, both in the Bunner case, has essentially agreed with. And so, for instance, in the Bunner case, which was another Federal Tort Claims Act case, Judge Johnston, as well as plaintiff's expert in that case and plaintiff's attorney, all utilized the terminology. The question was posed to plaintiff's expert: had the standard of care been followed in this case, can you say to a reasonable degree of medical probability that Mr. Bunner would have experienced a greater than 25% chance of improved outcome? And the answer was yes. So throughout that decision, the Bunner case, which was a 2016 case, the terminology of better outcome is improved outcome is certainly in that case and utilized, and it's only a common sense approach in trying to determine what the outcome would be. So as Judge Faber has indicated in both of his orders, which appellant is appealing here, you could have the situation of 25.01% and then 24.99%, and everybody would agree that's not a substantial factor. It's 0.02 of a percentage point. So the plaintiff should not be allowed to proceed if they do not prove that the difference in outcome would exceed 25%. It's just, the appellant in this case would have you take a snapshot in time and look at.
But Mr. Fox, that's just not what the statute says.
Well, the statute doesn't go into detail with regard to how this calculation should be made. You're correct, Your Honor.
Well, no, the statute says pretty clearly that you can't recover if you wound up with less, if under optimal circumstances, or at least reasonable circumstances, you would have wound up with less than a 25% chance of recovering or surviving. That's what the statute says.
Well, the statute says that following the standard of care would have resulted in a greater than 25% chance that the patient would have survived. And the issue for this court and what Judge Faber was faced with is, how do you determine that 25 or greater than 25% chance?
Well, you get experts to testify about it. Now, you know, you can get experts to testify about anything, and apparently they'll put a number on your chance of survival. But, and as Judge Rushing pointed out, you might lose the case if it's such a de minimis amount of malpractice, or you might not get a lot of money. But I mean, the 25% is kind of like a speed limit. It's an arbitrary number, but that's what statutes do sometimes, and this is one of those times, I think.
Yeah, and Judge, you're exactly right. And oftentimes you can get experts to say many things, but in this case, we're dealing with the plaintiff's own expert witness who testified about the percentage of survivability at one point in time, and then a percentage of survivability at another time. You'd think
he said it was going to diminish around % per hour, didn't he?
He said every hour that the patient wasn't transferred, it diminished by 10%. That's correct, Your Honor.
And he started at what, 50%?
He started at, well, if you do the calculations, it was 49.17%. And then his testimony was the patient needed to be transferred within 1 hour, and that would have met the standard of care. So you get down to 39%.
Did anybody ask him if the 10% was 10% of 100% or 10% of 49.1%?
That question was not asked, Your Honor. So, you know, and then.
But we don't know what he's.
Well, following the deposition, or at the end of the deposition, plaintiff's counsel did not ask.
We know that at the end of the whole thing, after the acceptance, that following the accepted standard of care would have resulted in a greater than 25% chance that the patient would have improved recovery or would have survived. So when they got to Roanoke, does that mean that would have needed to have had something better than 1 in 4 chances of living?
Well, when she got to Roanoke, and the testimony is that she had a 16.17% chance of survival. So the court in this case.
That's by calculating that 10% is 10% of 100%, rather than 10% of 49%.
I don't think the order from Judge Faber actually goes into detail about that. But what Judge Faber did was subtract that 16% from the 39% and comes up with 23%, which is less than the number in the statute. And that's the basis for his granting of summary judgment in this case. Again, you know, the plaintiff in this case.
He calculated, and you're supporting the proposition that when she got to Roanoke, she only had a 23% chance of surviving.
That's correct, Your Honor. Yeah, and it's certainly reasonable to look at the change in outcome, because that's my client shouldn't be held responsible for the 16% that when the patient got to Roanoke. That should not be. That should be the patient had by the time the patient got there.
Your client's the Bluefield Medical Center, and you're saying they didn't cause any delay.
That's correct, Your Honor. That's correct, Your Honor. So, you know, I see that my time's winding down. If you look at the cases of Bunner versus U.S., Davis versus U.S., and Wilkinson versus U.S.
Again, now, those 3 cases come from other district judges in Southern West Virginia?
That's correct. Bunner's from Judge Johnston, Davis is from Judge Berger, and Wilkinson's from Judge Copenhagen. And and especially Judge Johnston and Judge Berger's discussion in Bunner and Davis is especially interesting. As I've read to you earlier, they talk about improved outcome, and Judge Berger in particular ties the
counsel,
substantial.
To be clear, it does say a greater than 25% chance of a better outcome. But that's pretty much what the statute says when it's not talking about death, right? When it's talking about recovery. a 25% chance that the patient would have an improved recovery, not 25% greater recovery. They're not measuring the recovery. They're just saying a 25% greater chance that things would have been better, that the result would have been better. So I'm not sure that, I mean,
Yeah,
again, I know Brunner's just a district court opinion and they don't actually analyze the statute, but I think you're overreading it.
Okay. Well, as I indicated, and Judge Faber cited these cases as well in his order, and he felt that the improved outcome language in the Davis case, in the Bunner case, was especially interesting and supportive of his position in the McNeely case, in the Grant case. So, you know,
Did you think? I'm going to ask you what I asked your colleague there. Did you all think about trying to certify this as Supreme Court of Appeals?
We did not, Your Honor. We filed our motion for summary judgment, and the judge granted that. So no, we did not discuss certifying the question to the Supreme Court.
A lot of incentive to do that if you already won, right?
That's correct, Your Honor. That's correct, Your Honor. So again, as I see my time's winding down, based upon today's argument, as well as our previously filed briefs in this case, we would respectfully request that this court affirm the district court's December 19th, 2019 granting of our summary judgment, as well as affirm the June 25th, 2020 denial of the plaintiff's motion to reconsider. Thank you very much.
Thank you, Ms. Fox. We appreciate it.
Okay, thank you.
Mr. Byrd?
Yes, Your Honor. I just want to make a few points on, especially some comments made by Judge Rushing and by the counsel. First and foremost, if you look at Bunner, Bunner does not stand for a change in condition. Bunner stands for the proposition, and it is actually stated clearly, as Judge Rushing pointed out, chance of an improved outcome or an improved recovery. It does not talk about change in condition. And also, if you note in that case in footnote 17, the judge talks about how the 25% language is a threshold that has to be met. And I would just submit to Your Honors that the Wilkinson case, the Davis case, and the Bunner case do not stand for the proposition of how the district court interpreted the statute, which if you look at the district court's order in footnotes 8 and 10 where it granted it specifically states this: the court interprets West Virginia Code 55-7B3, which is loss of chance, as requiring a 25% change in outcome between the chance of survival had the standard of care been followed and the chance of survival experienced due to the breach of the standard of care. There is not one case, one statute, the language in the statute itself that supports that notion. And Your Honors, I would just submit that if you just look at the plain facts of this, at the time that the standard of care should have been followed by the appellee, Ms. McNeely would have a greater than 25% chance of survival. It would have been 39.17 based upon the court's calculations. Now, I have to point out what Judge Rushing said because it's an important point. The court used the difference between had the standard of care been followed and the time that she arrived at Roanoke because of the breach, showing that there was a 23% decrease. That is for counsel to argue before a jury whether that was a substantial factor, that increased of harm. They couldn't stop my client's bleed, so it increased her harm, which led to her ultimate injury. So when the jury hears that, they're going to have to decide whether that 23%, well, is that a substantial factor in bringing about her ultimate injury? That is for the counsel to argue to the jury, as Judge Rushing properly pointed out. So on behalf of the appellant, if you follow the clear language of the statute, as we've submitted, the ruling that makes sense is that this is, I mean, she met prong 2 that I discussed with Judge Rushing earlier. Her chance of survival at 1035 when the standard of care would have been followed was greater than 25%. End of story. Prong 1 of the loss of chance statute submitted to the jury. So the appellant is simply asking this court to recognize that there was a fundamental flaw in the district court's rulings that without any correction by this court would lead to an equitable result to the appellant. And so I just asked.
Now, what happened at 10:35? Did you say?
10:35, Your Honor, is if the standard of care would have been followed, she should have been at Roanoke. And those standards, the West Virginia cardiac catheterization standards, which are addendum to my brief, they were.
Well, they couldn't. On the record here, they couldn't have flown that helicopter to Bluefield and back in an hour.
Well, Your Honor, and I know that's not in the record, but in deposition testimony, the policies and procedures at the appellee, they're required to have a helicopter at one of the local airports, if I remember, but I don't believe that
happened.
But that was outside the record and outside the consideration of the judge. But yes, you're right, Your Honor. 10:35 is the time if the standard of care would have been followed. If the standard of care would have been followed, she should have been at Roanoke. And she would have had a 39.17% chance of survival, which is greater than 25%. Your Honors, I appreciate.
Anything else?
And we just asked that the court remand it and that the appellee be named as a defendant, and we move to trial.
Thank you very much, Mr. Byrd.
Thank you, Your Honors.
If we were in Richmond, we'd leave the bench now, and the three of us would venture into the well of the court and shake hands with each of you and thank you for your work. But maybe next year.
Maybe next time. Thank you, Your Honor.
We appreciate it, Your Honor.
Good to have you. Yes.
Thank you.
Madam Clerk, or Mr. Clerk, Mr. Coleman will take this case under advisement and proceed to the second case.
Second case on the docket today, case number 197276, Witherspoon versus Stonebreaker.
Yes. Thank you, Mr. Clerk. Mr. Corza, are you there?
Yes, sir, Your Honor. May it please the court, John Corzin with the Wake Forest Appellate Clinic. Good afternoon, Judge King, Judge Russing, Judge Gibney. Good Friday afternoon. Under Local Rule 46A, it's my pleasure to introduce the two student counsel on this case. Emily Washburn will do the opening, and then Rohan Shah will do the rebuttal. Thank you, Your Honors, very much.
Very good. Thank you, Professor. Ms. Washburn, please, we're pleased to have you with us. Thank you very much.
Thank you, Your Honors. May it please the court. My name is Emily Washburn, and I, along with my co-counsel, Rohan Shah, represent the appellant in this case, Lionel Witherspoon. Your Honors, this case involves a hung jury who had deliberated for 2 days, asked numerous questions, and been administered an Allen charge only to reach no verdict. However, upon the presentation of new evidence during jury deliberations and trial counselor's failure to object, the previously hung jury reached a unanimous verdict a mere 10 minutes after being presented with this new evidence. Today, this court has the ability to protect Mr. Witherspoon's Sixth Amendment right to effective assistance of counsel and reinforce the high standards of the legal profession. Your Honors, the state post-conviction court unreasonably applied federal law in this case for two main reasons. First, the state court conflated an attempt to object with an actual objection and then deemed that attempt to be in line with prevailing professional norms. And second, the prejudicial effect of trial counselor's failure to object is clearly demonstrated through the close proximity and time between the presentation of new evidence and the jury's unanimous verdict. Therefore, appellant Lionel Witherspoon respectfully requests that this court reverse the judgment dismissing his petition for habeas corpus. The governing standard for ineffective assistance of counsel claims, it was set forth by the Supreme Court in Strickland versus Washington. To prevail, a petitioner must satisfy both prongs. Yes.
You say that counsel didn't object. The district court here said the council did object. The magistrate judge here, United States magistrate judge, says that council did object. The state court down in PCR court down in South Carolina said the council attempted to object. And you say council didn't. What are we supposed to do with those differences?
Your Honor, the PCR court's classification as trial counsel's attempt to object doesn't amount to an actual objection that the trial counsel ruled on and is sufficient to preserve an issue for appeal. Here, as noted on page 246 of the joint appendix, counsel's exact words in response to the trial judge's question, any objection, were, "I would, Your Honor, but," and then she doesn't continue on. As also noted on that page, there was ample time.
PCR court heard the testimony of the defense attorney, the trial attorney, and found the counsel attempted to object. Aren't we bound by that?
No, Your Honor. The
counsel and the, as I say, the district court and the magistrate judge both said she did object.
Yes.
We are bound by that. You agree with me? We're not bound by what they said.
No, Your Honor. This is reviewed de novo, and the trial court there, or the PCR court, found.
What are we supposed to do with the facts? What are we supposed to do with the facts? The PCR court said they attempted to object, and and in your appeal papers assert as a fact that she did not object. Now that's a different set of facts, is it not?
Yes, Your Honor.
Why don't you accept the facts as determined by the PCR court?
The PCR court classified her objection as just an attempt to object, which is not an actual objection. And they based their ruling on the PCR hearing where trial counsel testified. And in her own words on page 292 of the joint appendix, she classifies her own statement as merely an attempt to object. And the respondent's brief.
Well, it's not even much of an attempt, is it? Because to begin with, her statement is conditional. I would object. And then she says, but, which sounds to me like she says, well, I would, but I won't.
Yes. Yes, Your Honor.
And I don't see how you can construe that any other way.
Yes,
counsel, I believe the PCR court noted, counsel testified that she was often cut off by the judge. She was presumably trying to be polite because she was in South Carolina courts for this PCR hearing, but this judge often would rule quite quickly on her attempted objection. So why was the PCR court unreasonable in reading the transcript to say, I would, and then the judge cuts her off as she's saying, but, and there goes her opportunity.
Your Honor,
why is that unreasonable?
The trial judge did object interrupt her 2 times previously on pages 197 and 198 of the joint appendix, and then on pages 230 of the joint appendix. However, at both of those times, he interrupted first while she was making a motion for a directed verdict, and the second time while she was making a suggestion for an answer to a previous jury question. However, both of those were conversational, and the judge and the trial counsel had dialogue between them. Here, trial counsel's words, I would, Your Honor, but, and then just stopping and not continuing to pursue that objection, nor state any grounds for the specific objection, is objectively unreasonable and doesn't.
I have a question on that. In your papers, you suggest that the reason that her objection was not sufficient or was deficient performance was because she didn't explain it fully enough to preserve an issue for appeal under South Carolina law. And I know the other side has some law where they say, no, this would be sufficient. But I had a question about, is your argument that she was deficient for failing to preserve the objection for appeal? Or is your argument that she was deficient for failing to draw the trial judge's attention to the objection and obtain a ruling?
Your Honor, we would argue both. It was deficient for her not to object to this and point to the fact that it was new evidence being introduced during jury deliberations, which the trial judge had already noted in refusing to answer previous jury questions is highly improper to supplement jury deliberations with the introduction of new evidence. But it's
Ms.
also—
Washburn,
Yes, Your Honor.
what should she have done? Should she have asked for a bench conference or insisted that, I mean, one could argue that at that stage in the trial, she didn't want to look like she was arguing with the judge, and that might be a somewhat acceptable strategy. But couldn't she have asked for a bench conference with the judge or made the dreaded speaking objection saying that, well, Your Honor, this needs to be explained fully with witnesses, and it's too late to do that, and it's confusing to the jury?
Yes, Your Honor. She could have done both. As previously noted on page 246, the record does state that there was a brief pause in the proceedings where Mr. Witherspoon was asked to stand. So she could have asked for a bench conference or for the jury to be excused if she wished to be heard on the objection outside of the presence of the jury. However, with prevailing professional norms, other defense attorneys have also objected in the presence of the jury and been heard on that. So that would have been a different option for her as well.
What's your best case that an attempted objection that was the counsel tried to object, but for whatever reason didn't get it out? What's your best case that is deficient performance and that it violates clearly established federal law, that is insufficient?
Your Honor, this South Carolina Court of Appeals held in Haskins versus Fairfield Electric Co-op that when a trial judge doesn't rule on the objection and then counsel doesn't pursue a ruling, that there's no decision for an appellate court to review. So because trial counsel here failed to object, failed to state a grounds for the objection, and failed to secure a ruling for the objection under South Carolina Rule of Evidence 103A1, her performance was deficient and did not preserve any issue for Mr. Witherspoon to have appealed, and also contradicted his Sixth Amendment right to effectively confront the witnesses or the evidence that had been presented against him.
Have you tried to make the prejudice showing that you would need to make for the appellate argument? So if your argument is that she didn't preserve it for appeal and that was so deficient to be that clearly established federal law tells us that's so deficient to be ineffective, then you need to show prejudice by proving to us that a court of appeals in South Carolina, if it had been able to reach the issue, if the issue had been preserved, that the South Carolina appellate court would have reversed the outcome here, right? The outcome would have been different.
Yes, Your Honor. And the prejudice prong has been met.
Ms. Washburn, you take position the law is clear in South Carolina on that the evidentiary part of the trial was over and it couldn't be reopened, right?
Yes, Your Honor. Your Honor, the
jury, this was right in the middle of the jury deliberations. But now, are you saying that the deficiency here was by the trial counsel only, or are you attributing ineffective counsel claims to other of the lawyers who represented your client along the way?
Your Honor, the ineffective assistance of counsel claim is confined to the trial judge in this instance or trial counsel because she did not object. Why
didn't you bring the claim against on the direct appeal? That lawyer filed an Anders brief.
Your Honor, I cannot speak to that.
That lawyer threw your client to the wolves, filed an Anders brief.
Your Honor, the issue was not preserved, and this court granted the oral arguments on the issue with the trial counsel alone. And to go back to Judge Rushing's point about
and the counsel on appeal from the PSR proceedings filed an Anders brief. Do you know what those are? Anders briefs?
Yes, Your Honor.
That's when you say there's no claim. There's nothing to raise on appeal. You
Yes,
tell the
Your-
appellate court in here. Well, you
yeah,
this fellow's had 6 lawyers, counting you all.
yeah, yes, Your Honor. And there was nothing to, sorry, go ahead.
Just looking at those raises concerns about me, to be honest with you. Go ahead.
Yes, Your Honor. And the issue was not preserved for appeal.
Lawyer, and she was the one who was under the gun. She was under the gun. She was sitting there in the jury deliberations and had to face that judge who'd been pushing her around during the trial. And she got pushed around right there, I think. But these trial lawyers got to be willing to plant their feet and make a record for their client.
Yes, Your Honor, and we would agree. And to go back to Judge Rushing's point, the South Carolina Supreme Court has held in State versus Hart, and the South Carolina Court of Appeals has held in State versus Pinkers that while the display of physical characteristics is non-testimonial, it does constitute evidence. So this was an improper introduction of evidence during jury deliberations. So that was clearly prejudicial to Mr. Witherspoon. And that's clearly denoted by the short time frame between the jury who had previously asked to be declared a hung jury and their unanimous verdict after a mere 10 minutes after being presented with new evidence.
What they did,
Didn't counsel testify?
Ms. Washburn, the case was reopened there during the jury deliberations, and additional evidence was presented. And the request to reopen didn't come from the prosecutor. He stood mute when all this was going on, I think. And the request to reopen the evidence came from the jury forum, of all people. He wanted the trial reopened to present additional evidence and said what the jury wanted, and the prosecutor stood mute. Like his obligation to somebody a fair trial.
Your Honor,
so go ahead.
Your Honor, the case was not.
If I were you, I'd just some advice. I wouldn't interrupt judges too much. But go ahead.
I'm sorry, Your Honor. I'm having a hard time hearing you. I didn't know that when you were finished. I apologize.
That's the drawback of the system we're under now. And I didn't mean to be critical of you. You're doing a great job. You go right ahead.
Your Honor, the case was not reopened in this instance. And just the jury's request, the trial judge does have discretion to grant jury's requests. However, the trial judges in State versus Winkler, the South Carolina Supreme Court held that while a court may permit juries to review evidence during jury deliberations, it's the review of it has to mirror the way that it was presented at trial. And in this case, it did not mirror it because Mr. Witherspoon was never asked to present his physical characteristics at trial, nor was this video zoomed in, paused, and enlarged for the jury to view, much less the fact that they were side by side. Your Honors, I see that I'm running out of time. May I briefly conclude?
You can, but I don't understand what you just said. I thought just exactly the opposite, that it was reopened. Not officially reopened, but effectively reopened for the picture and for the show up.
Your Honor, it wasn't officially reopened, and regardless,
trial. No, I agree it wasn't officially reopened, but as a practical matter, it was reopened at the request of the jury. It was reopened. Yes, I'm saying that in an effort to assist your client or you, not to be critical of you at all.
Okay.
I think in this instance, it was reopened.
Yes, Your Honor. And that just goes to show that trial counsel should have objected to the reopening of it in the presentation of new evidence during deliberations, which she failed to do. And Your Honor, the state post-conviction court's application of federal law was objectively unreasonable here. Trial court's attempt to object and her intentions to make a record were insufficient because intentions are not preserved in records, actions are. And here, trial counselor's failure to object to the introduction of new evidence during deliberations was clearly deficient and highly prejudicial to Mr. Witherspoon. Therefore, for the reasons stated in brief and oral argument, Appellant Lionel Witherspoon respectfully requests that this court reverse the judgment dismissing his petition for habeas corpus. And my co-counsel will be happy to answer any further questions you have on rebuttal. Thank you.
Thank you very much, Ms. Washburn. We appreciate you. Let's see, Mr. Evans.
Yes, sir.
Good to have you with us, Mr. Evans.
Thank you, Your Honor. May it please the court, my name is Tommy Evans, Jr. I am from the South Carolina Attorney General's office. I represent the respondent in this case. Our position is that the U.S. District Court truthfully stated within its order that the pivotal question is whether the state court's application of Strickland was unreasonable, which is different than whether defense counsel's performance fell below the Strickland standard. Our position is that the district court was proper in its ruling granting summary judgment. One, because the state court didn't make a proper application of Strickland in the PCR, applying it to the actions of defense counsel. Our opinion is that the defense counsel did make an objection. She was asked by the trial court, is there an objection? And she said, I would, Your Honor, but she was cut off. So we don't know what she was going to say after that period was being cut off by trial counsel. Also,
well, but Mr. Evans, it's contrary to objecting. I would object, but what means I'm going in the opposite direction?
Your Honor, I respectfully disagree because we don't know what.
Well, what doesn't? How can you say that? I mean, it's standard English.
Well, first of all, I think that is we're being speculative, which I don't think we should do in a case like this. We should go by what's on the record. Second of all, she can say, Your Honor, I would like to object, but I don't know if you can rule in my favor, or but I think this is improper. That's why I wanted to object. There's a lot of things that could have been said in that situation when she made that statement. But we don't know. It wasn't asked to her on PCR. I wish it would. So we have to go by what she said in the first part of that statement, that she would object.
Yeah, then you just eliminate the word but.
Yes, I would eliminate the word but because we don't know what she could say after that because she was cut off. So I don't know what was her intentions or what was her thinking. But the first
Do you agree, Mr. Evans, that if she had said to the judge, this is reopening the case, and you can't do that while the jury's deliberating, everybody knows that, he would have said, you're right. And that would have been the end of it. And they would have acquitted this poor fellow.
I don't know if he would have said that, Your Honor, because it was clear by the record that he was going to allow whatever the state wanted to see. Yes, sir.
Law of South Carolina in that regard was totally on her side. It was an objection that she should have made, and it was an objection that should have been sustained. The point is, she didn't make the objection. Is what your colleague on the other side there is saying. She didn't make the objection.
Well, of course, we wouldn't be here if they agreed with me, Your
Honor. By law, it should be made and should have been sustained because it's the law.
Well, there are case law.
They opened the case and put in additional evidence. And the defendant convicted in 10 minutes.
Okay. There is case law that basically saying that this is not reopening the case because the video was already in evidence. U.S. v. Washington was the D.C. Court of Appeals case. Pretty much says that, and it's pretty much on point with this case, that since the actual defendant was being seen when the trial, and he was identified by the congressional informant, it is not reopening the case. This is not putting new evidence. This is just an aid to the jury in order to make an actual truthful verdict in this case, because there could have been individuals in the jury that was not able to see him properly. Therefore, for the judge to order he stand before the jury so they can make a proper identification, that would give all jury members the same playing field in which they can make a proper verdict in this case. So it is our position
to come in the trial, though, be subject to cross-examination and all those things.
That was
the instance of the problem.
But that was the jury deliberations was not reopening the case. That's our position. It's no different than the case of U.S. v. George, where the jury used a magnifying glass in order to properly see evidence. It's the same situation. Our position was not reopening the case. It was giving the jury the ability to make a proper verdict in this case, giving them the ability to aid them in order to make the proper decision. If that was not him on the video, they can rule that he was not guilty. It can win either way in the situation. I don't think the trial court knew what they wanted to see, but it was obvious during the record that the trial court was going to let them see whatever they wanted to see, regardless of any objection that was made by defense counsel. And it's our opinion that defense counsel made a proper objection in that case. It does, for an objection to be an objection, it doesn't have to be an actual stated the word objection. And all it has to be is a situation where the court realizes that defense counsel is going against what they're about to rule on and a ruling being made.
So are you arguing then that there was an objection interposed?
Yes. My argument is that she made an actual objection in this case.
You're saying she did object?
Yes,
sir. Public
sir.
defender objected in this instance. Okay.
Yeah, that's my position. Now,
and the PSR, not the PSR, whatever they call it now, the PCR.
Post-conviction relief.
That judge said there was an attempt to object, not that there was an objection. There was an attempt to object.
Yes, sir. I think he said that because that's what defense counsel actually said on testimony in PCR. But the district court and the magistrate, U.S. magistrate, said there was an objection.
Object is an objection.
Yes, sir. I mean, that's our position,
Okay.
that she actually made an objection because when she said I would, it was actually a ruling to the court. Yes, sir.
The argument had an attempt to object, as the PCR judge said, as found, an attempt to object equals an objection.
I would say
South Carolina authority or federal court authority that says that.
I don't know of any federal court authority or South Carolina authority. I mean, under Rule 103 of the South Carolina Appellate Court rules, the only time you would need to make a reason for an objection if it was not clear by the facts of the actual case. Which this case it is clear what she was objecting to. She was objecting to the court ordering his client to stand for that jury, and so our position is that that's sufficient because when you make an objection, it's only making this for one or two reasons. Either one, they exclude evidence, or two, to preserve a particular subject for appeal. And it was obvious in reading of the record, the judge who stated himself, whatever they want, I'm going to give it to them. So it was obvious that whatever request they was going to make, the judge was going to honor that request. So the only other standard to make an objection after that was to preserve the record. And our opinion is she did that. It was sufficient enough to preserve the record because she made a statement to the court and forced the court to make a ruling on that particular statement. That is all that is needed to be made in order to make an objection in the case. And
Well, but the thing is that, everybody was tired because they had been dealing with this case for a long time and they were sitting there and they were impatient. And maybe the judge was going to allow the evidence in come hell or high water, but I don't think the lawyer did anything to point him in the right direction to say this is essentially doing a show up or a lineup in the courtroom or creating a demonstrative exhibit or whatever you want to call it. It's wholly new evidence with a freeze frame on the video and Mr. Witherspoon having to stand next to it. If she had pointed that out, the judge would have said, "You're right."
From what I've read in the record, I don't agree with you. I just don't know the judge was going to do that. And being a former trial attorney myself, there are certain instances where you know where the court is going, and you know the temperament of certain judges. And
but
I don't
the
want
law,
to say, yes, sir.
the lawyer here isn't representing the judge. The defense lawyer here is not being the prosecutor. The defense lawyer's loyalty is to her client, not to herself even. It's to her client, not the judge. She had to act on behalf of her client. If she had objected under South Carolina law, as I've seen it, the objection should have been sustained. And so she should have objected because it was prejudicial. Seems to me, because show up right in the courtroom with this new evidence after everybody rested. They rested the case and argued the case, instructed the jury, and the jury deliberated. They'd even given them an Allen charge, dynamite charge, trying to break the tie, and it didn't work. So they did. This incident occurred, and if it's new evidence, they reopened the case effectively right there in the courtroom at the request of the jury.
I totally
anyway,
agree.
Go ahead. I didn't mean to take all your time. You go ahead. You got some.
I totally agree with you, Judge King. She does, is her obligation to represent her client. You're absolutely right. But sometimes in a situation like that, you know we'll have to pick your battles, and you don't want it to be more detrimental to your client than it should be. Even she said in PCR that if I was held in contempt, it wouldn't have helped my client at all. He would still have to stand up. So that's a judgment call that she made in that situation. I think under Strickland, we don't hold judgment calls against attorneys in situations because none of us are there in that situation. So therefore, personally, I think, and our position is that she made an objection. That objection was ruled upon. It was sufficient objection for the case to be, the situation to be appealed. And they didn't raise that in appeal. That was not this attorney's fault. That goes to appellate counsel. And maybe there should have been a PCR raised against appellate counsel in this case for not raising this issue in appeal, which was not done. If I may, I'd like to go to the second prong of Strickland.
There's by more than one lawyer along the way here. There have been six sets of lawyers, five sets before we got to the Wake Forest folks who are helping us out here now. And maybe it's a collective situation. Go ahead.
I understand your point, Your Honor, but the only cases before you today is the actions of the trial attorney. And our position is that she didn't do anything wrong. She might have not have been as vocal as anyone of us thinks she should have been. But I think that the assessment on Strickland is not what we would have done in that situation, but what she done in that situation, which was enough in order to preserve the record for appeal. And that's the only way that you would object to that situation. It is clear by the record that the trial court was going to grant what the jury wanted in that situation. So all she could have done in that period is to raise an objection, which she did. Wasn't as vocal and as forceful as I think any of us would like to have seen, but I think it was enough in order to preserve the case for appeal, and it should have been raised in appeal and not.
And that's
in PCR.
And that the question about whether she objected and the judge acknowledged the objection and said, I think it's proper, overruled her. That's a factual question, is it not? That the PCR court made a factual determination about what actually happened. Is that right? Or is this a legal question for us?
I think it was a factual question, whether or not she actually raised an actual objection. which was ruled on by the PCR court. According to her statement, she says I attempted to object. And I think that's
and under EDPA, there's a pretty high standard of review, right, for us, for legal questions, but especially for fact findings by a PCR court.
Yes, there is, because this court obligation, or the actual district court's obligation was to make a determination of whether or not the PCR court followed Strickland, and not whether the defense attorney lived up to the prongs within the Strickland case, Sean. So yes, there is a pretty high standard that must be, that is raised in a particular situation as this. If I can get to the second prong of Strickland, whether or not any deficiencies, if there were different, would have made the results different. Our position is it wouldn't. And even though she testified in the PCR that she spoke to jury members and jury members changed their mind once that situation was done, our position is that that was nothing due to her actions. It was due to the actions of the trial court. And I would reiterate, it is clear on the record that the trial court was going to allow the request of the jury. There was nothing in the record that would show that the trial court had any other intentions but to force the appellant to stand to be actually shown up against the actual video. Personally, I don't think there was nothing that she could have done other than make it more detrimental to her client by getting in a shouting match with the court in front of the jury, which is already obvious that this judge didn't have the temperament for something like that. And I think that's the reason why she kind of stood down once she made her positions clear. But once the jury made that request to have that video played and to have the video blown up in that situation, the judge was going to allow him to stand and be there. So that is the actions from the court that changed the result of the case, not the actions of the actual trial attorney. Therefore, Strickland, the second prong, does not apply in this case either. And that's our position. And I said before, even if she objected forcefully and the judge ruled against her, I just don't know if it's been meritorious, because there is case law showing that this is allowable, that this is not reopening the case. This is not new evidence. This is not testimony. This is just a defendant that was being allowed to aid the jury in making a just decision on this case and fair decision.
That is not evidence, right?
The evidence, the video was already in evidence. Yes, sir.
You're saying this was not evidence. That's the position of the state of South Carolina, that this was not evidence.
Yes, sir. It was not
Correct?
evidence. Yes, sir.
All right. I'm with you. I understand.
Okay.
What evidence? What was it?
It was, the video was evidence. This was an aid to the jury in order for them to make a decision. It's no different than a jury member using a magnifying glass or asking the court to enlarge the picture that was already in evidence for them to be able to make a decision regarding this case. I'm sure the jury wanted to make the right decision in this case. And surprisingly, they were a reflection of the side mirror of the person in the back seat. So I'm sure the jury wanted to make sure that the person in that mirror was either the defendant or not. And that's all this was, is for the jury to make a fair decision regarding if that was the person in the back seat who obviously made the drugs transaction. There was no doubt about that. Whoever in the back seat of that car made the drugs transaction. The question was that the defendant or was it not the defendant? And by making
what Judge Gidney asked you, what if it wasn't evidence, what was it? I can't understand your.
It was something to aid the jury to make. Yes, sir.
Tell me specifically, what was it if it wasn't evidence?
It was an aid to the jury to make a fair decision. That's what it was.
Was it aid to the?
Yes, sir. It wasn't evidence because the video was already in evidence. It was something that was already in evidence, and the jury used that video to make an aid and use the actual show up to aid them to make a fair and just decision in this case. Because if it wasn't the defendant, they would have found him not guilty, of course. I'm almost out of time, so I would just ask this court to affirm the decision of the district court in issuing the summary judgment motion. And I will thank you for your time and attention this matter. Thank you.
Thank you, Mr. Evans.
Thank you.
Good to have you with us. Appreciate it. Mr. Shaw, you're going to do the rebuttal.
Yes, Your Honor. Good afternoon.
Good to have you with us, Mr. Shaw. Thank you for your work.
Thank you, Judge.
Go ahead.
All right, may it please the court. Good afternoon, Your Honors. I just have a few points on rebuttal. The first point is to Judge Gibney's point about the reasonable probability under the Strickland test for counsel's errors, a potential reasonable different outcome may have arisen. And previously to this video being shown as new evidence to the jury, there were two jury questions that the trial judge stated that he would not answer because it would be highly improper to supplement evidence in jury deliberations since those questions did not arise at trial. And this is seen on page 229 of the joint appendix. And therefore, if trial counsel had made another objection to make sure that the judge had even heard her, because from the record, unlike what opposing counsel states, it's unclear whether the trial judge even heard her. We don't know about the time in between. So just another objection just to preserve the appeal for record, preserve the objection for record. And it's clear that trial counsel knew how to preserve an objection for the record. On page 241, she states that there was an Allen charge that she objected to within judge's chambers, which wouldn't be on the record, and then came back on the record and stated, Judge, just to preserve this for the record, I want to just state that I did object to this. So it's clear that she knew how to preserve a record for potential appeal. And therefore, if she had made an actual objection and stated that this was highly improper and new evidence, then there's a reasonable probability that the trial judge would have agreed with her along those points, considering that nearly a few minutes beforehand, he had refused to answer jury questions that he stated would be bringing new evidence into jury deliberations.
Well, counsel, I appreciate your argument. I'm not sure that just showing a reasonable probability is your standard here, though, right? Because you have AEDPA in addition to Strickland. So you have to show that there's no reasonable argument that counsel satisfied Strickland. That's what the Harrington case says, right? So you have two layers of review. So you have to not just show that there is a probability of a different outcome, but that there's actually no reasonable argument that counsel satisfied Strickland.
Yes, Your Honor, that's correct. Under 2254 D, it's the unreasonable application of clearly established federal law. And this is sort of construed differently because we're not arguing the contrary to point, but we are arguing the unreasonable application of of law of the Supreme Court. And in fact, the Strickland test bases it off of a reasonable probability of but for counsel's errors, and then the prejudice point, which Judge Rushing, you mentioned earlier. And it's clearly deficient not to object to something like this because it's based off of prevailing professional norms. So again, even despite the fact that this is not an objection, one more objection just to ensure that the judge heard her and to ensure that there's a reasonable probability that the trial judge would have agreed with her and stopped this from happening. In fact, there was a brief pause in the proceedings, as co-counsel mentioned earlier. There's even a time when in the PCR testimony, trial counsel states that Mr. Witherspoon looked back at her for wisdom and she stated, the judge has asked you to stand, you must stand. She could have made an objection at that point as well to preserve it for the record. And even in the PCR hearing, she could not state a reason or a trial strategy that she didn't object. And that's just that states to the fact that there was no objection in the first place. She said if there's one thing she could do differently, she would have objected, and because that was the most detrimental to her client. And Your Honors, the last point I will make is to opposing counsel's contention that this wasn't new evidence. In respondent's brief, opposing counsel states that the evidence in jury deliberations can be shown, but only if it mirrors presentation at trial. And here it's clear that there was no mirroring presentation of trial. There's combination here on the prejudice point. The fact that Mr. Witherspoon was asked to go and face the jury instead of his side profile, and the fact that a video shown during trial was now paused and blown up. So it became a still image, which is a completely new form, and therefore does not mirror its presentation at trial, and therefore was highly prejudicial.
You're saying what they presented to the jury there was a new piece of evidence?
Absolutely, Your Honor. That's exactly what I'm saying. The combination of Mr. Witherspoon standing up.
It was a blow up.
That's exactly right, Your Honor.
What was the size of it?
Your Honor, we don't know the exact size. However, we do know that a screen dropped down from the top of the courtroom and that it was blown up. However, there's no size mentioned in the appendix.
But what was the size of the screen?
Your Honor, we also do not have this information. It was not stated in the joint appendix. All we know that it was blown up, and it was clearly pixelated as well, which trial counsel stated in her PCR testimony.
The PCR judge knew the size of the screen, right? Because it was in the same courthouse, it sounded like, from reading the testimony.
Apologies, Your Honor. Yes, Your Honor. That's correct.
I mean, it's not in the record, but the PCR judge knew because they talked about it.
That's exactly right. The PCR judge would have known in the testimony. However, the actual size is not in the record that we are here with today. And Your Honors, therefore, Mr. Witherspoon respectfully requests this court to reverse the judgment dismissing his petition for habeas corpus. Thank you.
Yes, and thank you, Mr. Shaw. And we want to particularly thank both Ms. Washburn and Mr. Shaw and Professor Corson for your work in this case, and Mr. Evans for your argument as well. And if we were in Richmond, we'd at this point introduce ourselves more formally and shake hands with counsel, or at least tell you how much we appreciate your work. And the next time you come to Richmond, I hope we can do that.
Thank you, Your Honor. Always an honor, and enjoyed meeting you too, Mr. Evans. Thank you all.
Thank you.
Thank you.
Thanks very much. And Mr. Clerk, give us a 5-minute recess. I assume
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. The last case on the docket today is case number 197482, Slusser versus Vereen.
Mr. Swanson,
Yes, Judge.
you there?
Yes,
Good to
Judge.
have you with us, sir. You may proceed.
Thank you, Your Honor. May it please the court. Brady Swanson on behalf of Larry Slusser. Section 2255E exists to ensure that prisoners have a meaningful, unobstructed procedural shot to test the legality of their sentence. When in extraordinary circumstances and through no fault of a prisoner's own, Section 2255 proves inadequate or ineffective to test the legality of the sentence, then the Savings Clause says that 2241 traditional habeas relief remains available. And what happened in Mr. Slusser's case is extraordinary. The Sixth Circuit, after granting a certificate of appealability on his 2255 motion, ultimately refused to reach the merits, concluding that he had waived it in his plea agreement. Less than a year later, in a subsequent panel opinion, and after denying rehearing in Mr. Slusser's case, the Sixth Circuit essentially confesses error and singles out Mr. Slusser's case by name as wrongly decided. But by then, of course, it's too late for Mr. Slusser to secure relief through Section 2255. Under those extraordinary circumstances and this court's precedents in Wheeler and Braswell, Mr. Slusser is entitled to pursue relief under Section 2241.
Can I ask you a question, Mr. Swanson?
Of course, Judge.
When we get down to the merits of his complaint, hasn't the Sixth Circuit decided in several cases, Brumbeck, Buey, and Brown, that the offenses that were used to enhance this gentleman's sentencing are in fact proper offenses to use to find somebody eligible under the Armed Career Act?
We've kept the court updated through our 28J letters as to the status of the cases in the Sixth Circuit. And of course, the circuit does apply Sixth Circuit substantive law in ruling on the petition. That said, as with any other panel opinion, this court can't apply precedent that is contrary to binding Supreme Court precedent. And here the Supreme Court said in James versus United States that attempted burglary is not burglary for purposes of the enumerated offenses clause. And the Sixth Circuit has never engaged with that, not even in the dictum in Brown where it attempts to address this issue on the merits. The Sixth Circuit doesn't acknowledge James, doesn't respond to James. It doesn't explain why James is inapplicable here. So although we recognize that the Sixth Circuit has purported to address this issue in a series of panel opinions, our position is that the result it has reached in those opinions is simply contrary to the Supreme Court's opinion in James. And it also runs counter to precedent from both the Supreme Court and the Sixth Circuit, pre-existing circuit precedent in the Sixth Circuit, saying that the modern generic version of defense is defined by looking to the majority approach in most states. And here it's undisputed that the majority approach to generic burglary does not define entry to include an instrument that is not used for the felony, to preserve that line between burglary and attempted burglary. Again, that's something the Sixth Circuit doesn't engage with in Brown and doesn't respond to. So we think that although those precedents do purport to resolve the issue, there is still an argument to be made on the merits. But of course, the court can't reach the merits without addressing a threshold jurisdictional issue.
Well, but the Fourth Circuit, or the fourth factor in the Wheeler test is essentially whether there's a fundamental injustice in this thing, and given what the Sixth Circuit has held, is there a fundamental injustice? I mean, you may think it's wrong, but aren't we kind of bound by what the Sixth Circuit says about Tennessee law?
Oh, well, Your Honor, as I said, we do think that when you get to the substance on the merits, you apply Sixth Circuit law. That's certainly true. At the same time, this court has said that for purposes of the Wheeler test, which defines and interprets Section 2255E, the issue affects subject matter jurisdiction. And subject matter jurisdiction generally assumes that a claim on the merits will be successful when assessing jurisdiction, right? And then you get to the merits. But the Supreme Court has always policed that line between jurisdiction and the merits. So I think it would be a departure from customary rules of civil procedure to assess jurisdiction by reference to the underlying merits of the case.
Well, but what's the fundamental defect that we have to find in the fourth factor of the Wheeler test?
So the fundamental defect, you would assume for purposes of the jurisdictional inquiry that it's sort of like, you know, a failure to state a claim, right? You would assume the truth or the merits. And if we've stated a claim on the merits, would it present a fundamental defect? And I think here there's no dispute that it would, because in Mr. Slessor's case, if the ACCA predicates are erroneous, then you've raised you've actually put his mandatory minimum sentence above what should be the statutory maximum. And under Wheeler and Lester and Hahn, that is a fundamental defect in the circuit. So again, I think for purposes of the jurisdictional inquiry, you're not assessing whether the merits are correct or not. You're assessing whether we've stated a claim of a fundamental defect. And then once you get to the merits, of course, then you have to decide whether the Sixth Circuit precedent governs. And yes,
Counsel, on the jurisdictional question, I want to make sure I understand your argument. So your client satisfied the gatekeeping requirements of 2255H2 on exactly this claim, right? On the same claim you're making now. He satisfied the H2 requirements. A district court reviewed his argument on the merits, his claim on the merits, and denied it. And
that's correct.
Right. So how does this get us into a territory where 2255 was inadequate or ineffective if your client has in fact already received review on exactly this claim under 2255?
Well, under section 2255, there's a right of appeal if you make a substantial showing of a denial of a constitutional right. And the Sixth Circuit found that Mr. Slessor had satisfied that showing, and so he had a right of appeal. And so his
So what if the Sixth Circuit had denied a COA erroneously? They had denied a certificate of appealability, but if they had applied the standard correctly, they should have.
So I think the rule that we're stating is it only comes into play. The extraordinary circumstances we're citing here only come into play because of the Sixth Circuit's confessed error in Mr. Slessor's case, right? So,
so I know I'm asking a hypothetical, but that's the whole fun of this is I get to ask questions that have nothing, that aren't actually your case. So, what if instead of granting a COA and then dismissing the appeal on procedural grounds, what if they denied the COA? And they were wrong to do so, but they denied a COA. Is your argument that would make 2255 inadequate or ineffective?
No, Your Honor, we don't think so, because essentially this court has said that the pathway that exists is for exceptional circumstances. Braswell says you can't punish the petitioner for being too diligent. And that's essentially what would be happening here, right? But that only happens because of the Sixth Circuit own admitted error in resolving his case, right? And so it wouldn't, that kind of extraordinary circumstance wouldn't exist in a situation where somebody comes into court just claiming that the Sixth Circuit got it wrong and basically.
So where in 2255E is your, it sounds like you're saying there's an extraordinary circumstance exception, right? That you get review. 2255 is adequate. It actually did test the legality of your client's detention, but the result was erroneous, and not just erroneous, but extraordinarily so. Is that your test for the saving clause?
I don't think that's my test. I think that's the test that this court has set out, because if you look at cases like Braswell and Hahn, you have people who literally filed 2255 motions on the same exact issue before they came to this court in 2241 posture. Those had been denied on procedural grounds, and then they came up. And I think that flows directly from the statutory text, Your Honor, because section 2255E says that the exception exists for circumstances when someone who is authorized to file a 2255 motion, but what is the language? It says they have either failed to apply for relief or the court has denied him relief, right? So the exception only comes into play into a subset of cases for folks who are A, authorized to file 2255 motions, but who've been denied relief. And as you said, maybe in that situation, 2255 is adequate, but that's not the only test. The statute says inadequate or ineffective, and we presume that Congress means two different things when it uses two different words. And so perhaps 2255 was adequate, but it was ineffective. And the reason it was ineffective...
Go ahead, tell me the reason it was ineffective.
So the reason it was ineffective was because of circumstances totally outside the petitioner's control.
No, you're saying it was ineffective because they got it wrong, right?
Yes, and because they admitted error in his case.
They admitted they got it wrong.
Yes.
Okay.
It's an right. So this court's precedent in Rivera, Braswell, so the test in Braswell, right? The court says that that the petitioner is able, notwithstanding his prior unsuccessful 2255 raising the exact same issue, the court says he could not rely upon the change in substantive law to correct the fundamental sentencing errors because of circumstances that were outside of his control, right?
Right, but that's where the law changes. That's where the law, he didn't have an argument before that now he has. Your client always had this argument. In fact, he was heard on this very argument in the district court. This is quite different.
Yes, although I think it's important to note that not even the government defends the district court's reasoning in this case. And again, the remedy in 2255, the full complete remedy, which is what the statute refers to, it includes that right to appeal and not just the right to be heard in the district court. So the question is whether that remedy was inadequate or ineffective. And in this case, it was ineffective because of the Sixth Circuit's admitted procedural error. So again, I think that the precedent that this court has laid out is that the unobstructed procedural shot is what 2255 guarantees, and in situations where it is inadequate or ineffective, that is, where through no fault of the prisoner's own, they have been unable to take advantage of a retroactive change in the law, they are entitled to pursue relief under Section 2241. And those are the exact circumstances that we have here.
This is kind of awkward when we're you asked us to review the Sixth Circuit. We're not an appeals court for the Sixth Circuit normally.
Well, that's what makes these circumstances so unusual, is that the Sixth Circuit has already confessed error in Mr. Slessor's case. So we're not asking the court to sit in judgment of the Sixth Circuit's review. We're not asking the court to take another look at something the Sixth Circuit did and say, well, do you agree or disagree? We're asking you to just give effect to the ruling that the Sixth Circuit already made in Mr. Slessor's own case. And Judge Rushing, I just want to come back to something because I want to make sure I was clear about sort of the analytical framework that I'm applying here. So the test that exists is the Wheeler test, right? There are 4 prongs. Until the government's 28J letter on the first prong, it had never disputed that Mr. Slessor literally satisfies the text of those prongs. And the reason specifically that he fails to satisfy the third prong is because he's making an argument that was previously available to him in the most recent federal proceeding, right? So that is the third prong. So the only question then is whether there's this bar or this independent bar on relief through the Wheeler test when you've got a situation where someone has filed a previous 2255 that's unsuccessful. And that's what, the language in Jones and Vial sort of gets at, is situations where you've got someone who's filed an unsuccessful 2255 before. But Hahn and Braswell clearly show that merely having filed one and not having met success in the 2255 context is not a sufficient reason to cut off relief under the Wheeler test, because that's exactly what had happened in those cases. And so the question is, well, when do you cut it off because of the 2255? And the answer is to look at, at what Wheeler calls the flexible and the adaptable remedy of habeas. Its precise application and scope change depending on the circumstances. And here, just look at the extraordinary circumstances. All we're asking you is to look at the extraordinary circumstances that happened in Mr. Slessor's case and say that, in those circumstances, 2255E proved inadequate or ineffective through circumstances that were no fault of the prisoner's own. That's the language that this court said in Jones and repeated in Wheeler. That's not language that I've just sort of come up with because it sounds good. And so I think if you apply the precedents that this court has laid out, there really isn't an obstacle to relief on the jurisdictional issue. Thank you.
And you want us, you're saying we just need to address the jurisdictional issue, to vacate it and send it back for consideration in South Carolina on the merits issue?
We have asked that this court go ahead and address the merits as well. I realize that's an unusual request, but it's a purely legal issue. It's one that doesn't really need factual development. And if you think we're right about the circumstances here, then Mr. Slusser started over-serving his sentence in June of this year, approximately. If you look at J6, you can see his arrest date. So he is already in excess of the statutory maximum in our view. So a remand would unnecessarily prolong his relief.
Because the maximum statutory sentence would go from 15 years to 10 years.
Correct. Yeah, his maximum sentence under the statute would be 10 years.
But still, that's an extraordinary remedy that's requesting here.
I'm sorry, I don't think I understand the question, Judge.
Well, you're asking us to go ahead and address the merits. That's what we normally are. We're a court of review rather than first view. And the only thing the district court considered here was the jurisdictional question.
That's unquestionably true, and we can see that. But the court has said in several cases, we cited one in our brief, where the issue is purely legal and likely or required to come up on remand. It is acceptable for this court to address the question in the first instance. So that's what we're fully briefed.
Anything else, Judge Gibney? Judge Rushing?
No, sir.
No, thank you.
Thank you, Mr. Swanson, and you saved a few minutes. Ms. Washington?
Can't hear you, Ms. Washington. You're muted. Ms. Washington, there you go.
No, you're still muted. I can't hear you.
Try turning your volume up, maybe, Ms. Washington. It's not showing you're muted, but we can't hear you. No. We can't hear you.
Are you there, Ms. Washington?
She's here. We can see her. We can't hear her.
Can you hear me now?
There you go.
Yes.
Yeah.
I'm sorry.
There you go. I can hear you now, Ms. Washington.
Great. Good afternoon, Your Honors. My name is Lisa Washington, and I'm representing the acting warden at FCI Edgefield. The district court got it right in correctly dismissing Mr. Slusser's 2241 petition for lack of jurisdiction, and this court should affirm. There are multiple reasons Mr. Slusser's claim cannot invoke the savings clause, but the bottom line, as Your Honors have picked up on, is that post-Johnson, the Sixth Circuit has held under United States v. Brumbach, United States v. Brown, and most recently in US v. Bowie, that aggravated burglary are categorically crimes of violence under the Armed Career Criminal Act. Even if Mr. Slusser were able to satisfy all of the other prongs of Wheeler, he could not show that Johnson represents a retroactive change in the law that renders his sentence fundamentally defective. And to the extent that there's a question about whether or not the court should get into or consider the merits of the argument in determining whether or not jurisdiction exists, prong 4 of the Wheeler test says that due to this retroactive change in the law, the sentence now presents an error sufficiently grave to be deemed a fundamental defect. In this particular case, the merits of the claim kind of collapse into the jurisdictional argument. Mr. Slusser was convicted, or at the time Mr. Slusser was convicted in 2011, he had 4 separate and distinct Tennessee burglary convictions. He also had a 1999 conviction for a serious drug offense, which was unaffected by Johnson. None of the convictions relied on by the government that are found at JA 102 through 108 were before the Sixth Circuit on appeal, and none of those convictions have anything to do with the claim before this court. Mr. Schlusser has 2 more than the required 3 predicate convictions to support his mandatory minimum 180-month sentence under the Armed Career Criminal Act. He is serving a lawful sentence. He can't meet prong 4 of the Wheeler test. This court said explicitly and clearly in Farkas that 2255 or constitutional claims are meant to be brought under Section 2255. Whether or not Mr. Schlusser's claim, whether or not 2255 is adequate to address Mr. Schlusser's claim is not a theoretical argument. As the court noted, after Johnson, after the decision in Johnson and after it was deemed retroactive in 2016, Mr. Schlusser's case fits squarely into 2255H. He brought his claim. He challenged both the validity of his aggravated assault claim post-Johnson under the residual clause and his Tennessee burglary claims. The court decided against him on the merits. Pursuant to a certificate of appealability limited to the aggravated assault claim, Mr. Schlusser argued unsuccessfully before the Sixth Circuit that his aggravated assault conviction was not a valid conviction for ACCA purposes post-Johnson. Granted, the court did not decide that appeal on the merits. Instead, the court decided the case based on the waiver. Now, the appellant makes an argument that the Sixth Circuit erroneously decided Mr. Schlusser's appeal on an invalid waiver. I do want to point out that to characterize the Sixth Circuit's decision in Schlusser 2, the appeal for the Sixth Circuit in 2018, as an erroneous decision based on a subsequent unpublished opinion, United States v. Vowell, is incorrect. Schlusser 2 is a published opinion, and whether or not Vowell believes that the panel in Schlusser 2 got it wrong is of little consequence. Under the prior panel rule, an unpublished opinion, that is, Vowell.
You're asking us to rule on a Sixth Circuit procedural rule. Asking us to rule in your favor on a Sixth Circuit procedural rule.
Your Honor, I'm not. The waiver argument in the government.
You're saying that the prior panel rule, I assume you're talking about the Sixth Circuit's prior panel rule.
Yes, Your Honor. The government's.
You are. Well,
the government's position, Your Honor, is that the Vowell case or the waiver issue is a red herring. The government's not relying.
The Sixth Circuit procedural rule, has the Sixth Circuit procedural rule been briefed here?
No, Your Honor. And the government's not relying on the. Excuse me, Your Honor.
I'm here. I was waiting for you. So it hasn't been briefed. The Sixth Circuit procedural rule that you want us to abide by hasn't been briefed in this case.
Your Honor,
that I'm familiar with. Maybe I haven't read something that you submitted. I'm sorry if I haven't.
No, you are correct, Your Honor. But let me be clear. The government's not asking the court to consider the Sixth Circuit's ruling on whether or not Mr. Schlusser's appeal was correctly decided on what they termed a valid waiver. I only point out the Schlusser 2 and the subsequent unpublished opinion because the appellant claims that the Sixth Circuit has confessed error in regards to its decision on Schlusser's appeal. That is not the case, Your Honor. Schlusser 2 is valid law in the Sixth Circuit, and in Vowell, the Sixth Circuit did not confess error. That's my only reason for pointing it out. Otherwise, it's a red herring. It relates specifically to Mr. Schlusser's 1999 aggravated assault conviction, which the government's not relying on. The Tennessee burglary convictions were not before the Court of Appeals in the Sixth Circuit. So I only point out the Bowell opinion and Slusser 2 to let the court know that the government believes that the appellant's characterization of the Sixth Circuit era is not correct. Now, I understand that Mr. Slusser is also arguing that because he's not able to bring a third 2255 motion, because now Johnson is not available to him, to invoke the savings clause. Mr. Slusser's reading of the term previously unavailable would turn 2255 or the gatekeeping provisions under 2255 on its head. The fact that the Johnson claim is not available to Mr. Slusser in a third 2255 motion is because he's already brought the claim in his second 2255 motion. To accept Mr. Slusser's reading of the term previously unavailable would basically convert Section 2241 into an appeal mechanism for an unsuccessful 2255. It cannot be so that 2241 is an avenue for rehearing unsuccessful constitutional claims. Mr. Slusser had a shot, an unobstructed shot, to bring his claims before the District Court and the Sixth Circuit Court of Appeals. The fact that the result was not what he had hoped for is of little relevance when it comes to the savings clause. The savings clause is concerned with process, not outcome. Just as an already denied constitutional claim is insufficient, a procedural bar, whether it be a voluntary appellate waiver or missing a deadline, a filing deadline for 2255, they're also insufficient to render Section 2255 inadequate or insufficient to handle or to test the legality of Mr. Slusser's sentence. This court stated in Farkas that a test is not inadequate or ineffective just because someone is unsuccessful or fails at it. And that's the situation we have here. To allow Mr. Slusser to circumvent the gatekeeping procedures under H2 is to basically just grant him a do-over, simply by asserting that 2255 is inadequate or ineffective to test his claim when all the evidence points to the contrary. Balancing the need for finality in criminal judgments and the need to correct erroneous decisions in sentencing and in convictions is what this court considered in Wheeler and Jones in outlining when the savings clause may be used to challenge a sentence or a conviction. As the court in Jones stated, allowing a 2241 application for a constitutional claim, like Mr. Slusser is asking this court to do, one that does not fit within the narrow exceptions under the savings clause, would basically nullify the gatekeeping provisions under Section 2241, and the exception would eventually swallow the rule. Now, Mr. Slusser compares his case to the situation or to the defendant in Braswell. The Braswell case is easily distinguishable from Mr. Slusser's case. Mr. Braswell was caught between the passage of a new law caused by Simmons and its retroactivity. Mr. Braswell's claim was barred because of a function of 2255, the law, as a tool. The court was incapable of hearing his initial claims because of a deficiency in the statute. All of the parties agreed that Mr. Braswell's sentence was fundamentally defective, and that he, like the defendant in Wheeler, presented exceptional circumstances. That's not so for Mr. Schlusser. Mr. Schlusser's 2255 petition was heard on the merits in the district court, and he was denied relief based on the inadequacy of his claims. On appeal, he was denied a merits decision, not based on a deficiency in section 2255 as a tool, but rather on a fact present in his case. And under still binding circuit precedent in the Sixth Circuit, there's nothing in Braswell that suggests that its analysis should extend beyond the statute itself, the 2255 statute. Mr. Schlusser's claim should be denied. It was denied at the district court. For all the reasons I've just stated, this court should affirm the district court's dismissal of his 2241 petition because he cannot meet all of the tests or elements under Wheeler. I'm happy to answer any questions that the court may have.
Hearing none, Ms. Washington, we'll thank you very much for your presentation and commend you for it. And we will hear from Mr. Swanson if he has some rebuttal.
Yes, sir.
Just a little bit, Your Honor. I'm mindful that it's Friday afternoon, so I'll try not to keep you. First of all, I just want to clarify something. Ms. Washington is mistaken that Val was unpublished. Her confusion is completely understandable because it did initially issue as an unpublished opinion, but it's now published at 938 F3rd 260. And if you look it up there, you'll see a little notation after the filed date that says this decision was originally filed as unpublished, and the court has now designated the opinion for publication. So it was initially published, but became published.
That's the Sixth Circuit case.
Yes, the one that designates Mr. Schlusser's case is wrongly decided. So it was wrongly decided in a subsequent published panel opinion.
Am I right or wrong that that Judge Donald was on both of them?
She was, yes. Judge Donald authored the opinion in Schlusser, and then was, I suppose, persuaded that her opinion in Schlusser had misread the prior pre-existing Sixth Circuit precedent in Carruthers, and thus joined the opinion in Val holding that Schlusser was wrongly decided. So I just wanted to clarify.
Judge Nelson wrote this opinion you're talking about?
Judge Moore, Judge Karen Nelson Moore.
There's more.
Yes,
more
that's
about
right.
This one. But does that make any difference whose names are on these opinions?
No, the names certainly don't. And I don't really think the published status.
Does the fact that there was a common panelist on the two of them make any difference?
No, I don't think it really does. And I don't think the published status really makes a difference to our argument either. The fact is a subsequent panel felt empowered to disregard it as non-precedent. So I think that's the main fact that matters, but I just wanted to make sure that I had clarified that. Second, on whether this court can assume the truth or reject our claim on the merits as part of its jurisdictional analysis. I just want to push back on that a little bit because the Supreme Court has continually maintained a line between jurisdiction and the merits. In Chafin versus Chafin, which was a mootness case, the court specifically reverses for conflating jurisdiction with the merits. And there's a reason for that. If you look at Arbo, YNH, it's because of the drastic consequences that go along with subject matter jurisdiction. If the court were to hold that this court can look to the underlying merits in assessing whether a Wheeler claim is valid, it would hold that basically the government is exempt from forfeiture rules, even on the merits of subsequent 2255 claims, which would be a pretty dramatic consequence that this court has never suggested is true.
What do we do with that Wheeler prong 4? Is that a problem with the Wheeler test? That the prong 4 does seem to ask about the merits, but it's a jurisdictional test, so we can't get to the merits. What do we do with that?
Exactly, and I think Your Honor is exactly right. And I tried to explain it sort of like a motion to dismiss in my opening argument. You sort of assume that the claim is true on the merits. Would the result be a fundamental defect? And then eventually you get to the merits and you can decide whether it's right or wrong. That would be a more traditional.
I'm
sorry?
You think we look at it through a lens of 12b-6 or something like that?
Not exactly, but it's an analogous procedure. And I think that would make perfect sense, given the nature that it is a jurisdictional test, and because of the dramatic consequences of holding that it's not jurisdictional. And the court has said, Wheeler is not to be read in a literal and isolated fashion. It's a flexible test. So I don't think there's anything wrong with sort of developing Wheeler as sort of the common law test that it is, so to speak. On the substance of the jurisdictional argument, Ms. Washington claimed that we would basically convert our 2241 into an appeal mechanism. That's not correct. We agree that the language that this court has repeated from Vial and Jones and in Farkas does provide some substantive limitation, but to look at the content of that limitation, it's not as easy as just saying there was a prior unsuccessful 2255, because otherwise Braswell and Hahn would be wrongly decided. So it's not a situation where we're inviting you to speculate. We're saying you look to whether there have been extraordinary circumstances, and here there have been, which is the Sixth Circuit's confessed error in the prior case. Finally, she says that the 2255 test focuses on process, but not outcome. Again, that test is derived from Prost versus Anderson, which is 10th Circuit law. That's not the law in this circuit. And so I just, I think that is really not the direction that this court has taken the 2255 inquiry. And again, that's because the text says it applies for some folks who are authorized to seek relief under 2255, but for whom it was inadequate or ineffective. Thank you.
Thank you, Mr. Swanson. We appreciate your work. And Ms. Washington, we thank both of you. If we were in Richmond, we'd come down and greet you in the well of the court. Can't do that now, so we're compelled to take your case under advisement. And Mr. Clerk, we will adjourn court for the day and sine die, I think.
Sine die.
This honorable court stands adjourned, sine die. Guys, save the United States and this honorable court.
Thank you.
Thank you.